I don't really,
general principle.
from my point of view, I don't really understand what the big to-do is over why that information is all of a sudden more secret than other information in state government. There is some legitimate, there are really, actually, very legitimate privacy and financial privacy and identity concerns about some of the information that falls into the hands of state government just because of doing its duties. And it's now been made clear by the federal and state courts that Social Security numbers, for example, of individuals are not to be disclosed. Those are redacted. Those are personal information. I don't really understand why owning a gun or not falls into that, but the legislature has spoken on that. You know, I will abide by the law and I will enforce the law, but my instinct is that unless there's some very legitimate concern about privacy of financial information or personal information that could be harmful if disclosed, you know, information should be disclosed.
As I recall, you responded pretty quickly on the email request when you released, more quickly than some of the other public offices did.
I actually don't know that any of the other offices have ever responded to it because they thought it was illegitimate, and we did that within a week.
So 6 months from now, if I come over and say I'd like every one of your emails you've sent as Attorney General, will you react the same way, or?
You can say it tomorrow about the Treasury. The thing that we're going to run into in the Attorney General's office, which is a legitimate issue that I didn't really have as Treasury because we're not involved in litigation, is there are a lot of attorney-client privilege communications in the Attorney General's office, so that is harder to sort through. I haven't wrapped my mind around how that will be. In my own office now, I don't see any reason why anything that I do isn't subject to public disclosure at all times. If we're talking about strategies in litigation, or there is factual discovery type information about a case that's being conveyed, then I think that's going to be a harder issue because we don't even have the ability to divulge it without the consent of our client. And the same would be true if you guys are in litigation. If somebody sues you for libel, or you know, or if you're in a public records case, you know, your communications with your attorneys are privileged. So the Attorney General's office will be a harder issue on that. Anything that we're doing in the realm of policy or legislation or anything like that clearly would not be subject to any privilege. And any, I would say also, probably most matters of administration in that office would not. But we will be dealing with lots of cases, and that will be a tougher issue. But let me say, if there are disagreements about any of that, I'm always willing. I say this, it's worked okay for me as county treasurer, it's worked okay for me as state treasurer, hopefully it'll work okay as state attorney general, that I'll have the time. I'm always willing to sit down, either myself or top staff, and hear from you as to what you think we're doing right or wrong, and hear your point of view, and let you understand our point of view, and see if we can, you know, reasonably understand each other in this sense.
We're coming up to time here.
You know,
Go ahead.
it's always bad to ad lib with some sort of policy proposal when you're in the middle of an ed board, but the Attorney General's public records training that they've done over the years, I've sat through that, and it's useful. In fact, it's very helpful if people actually pay attention to it. I don't know why we couldn't. Lisa here is a former journalism professor. I don't know why we couldn't involve the media and the press in those trainings. Have they ever done that? Has that ever been part of the Attorney General's?
I know.
I mean, have you come in and give your point of view to these local officials as to why it's important?